Okay. Okay.
Join. Sir, 3-4 minutes we will wait. 6-5 we will start, sir.
Shanmuga Priya madam, why delay in starting the program? Actually, sir may be having busy schedule now. Dr. Shanmuga Priya.
Ma'am, I asked it 6:05 we will start the program.
Okay, fine, right.
Only
Please
1 minute.
don't delay because sir may be having busy schedules.
Sure, ma'am. Sure, ma'am.
Yeah.
Sir, we'll start the program. Sir, Rahul sir?
Yes.
Yes. I'll start, sir. Guru Brahma, Guru Vishnu, Guru Devo Maheshwaraha, Guru Sakshat Parabrahmam, Dasmai Sri Gurave Namaha. Very warm welcome to one and all. I am Dr. Shanmuga Priya, Associate Professor, Department of Science and Humanities, St. Peter's Engineering College, Hyderabad. I welcome you all. I welcome our Honorable Secretary, TV Reddy sir, for this great program. I invite our respectful Principal Madam, Dr. Srilada Madam. I heartily invite our HOD, Department of ECE, Dr. Sarath Chandra sir. On behalf of the St. Peter's Engineering College, an institution of Innovation Council, I will happily and proudly welcome you, our chief guest, Dr. Rahul Kapoor sir, founder and director of Turnip Innovation, Mumbai. Nowadays, everybody facing a problem like responsibility of developing a society. Each and every day, we are all working for that in that various way. We do a lot of work for selecting a research topics, work on it, and finally finish our thesis. But how? We can prove our research have some uniqueness. Yes, here there are ways to prove our research into valuable intellectual property, that is patent. Yes, our research can also become a property, that intellectual property by the way of converting into patent. Now I hereby inviting our chief guest, Ms. Dr. Rahul Kapoor. He is a founder and director of Turnip Innovation. Sir had decade of experience in patent, information, science, teaching, searching, consulting, and multinational firms. He consulting multinational firms like General Electric and Robert Bosch. He completed his PhD in Innovation Management from LUT University, Finland, that is Lappeenranta University of Technology. Sir has published over 15 research articles in reputed international journals. He has a data architect of IPGRM, a global patent analytic platform converting over 100 million patents from more than 100 countries. Now, on behalf of our St. Peter's Engineering College and Institution of Innovative Council, I welcome you, sir.
Thank you. Thank you for having me.
Thank you, sir. Thank you so much.
If possible, can the chat be enabled for the participants? Just
sure,
see if it is possible. It would be great.
So
great. Good evening, everybody, and welcome. Really happy to be part of this. Really happy to see so many of you, coming at 6 p.m., which is great. Yeah, while I was doing my PhD, I worked with many technology commercialization projects, and I saw how the inventors struggle. They have no idea about patents, and they don't know how to commercialize. So it's very normal. So it is not like, so you don't, as inventors, you don't need to know 100% details about patents. But if you only know 20%, some tips and tricks, it can, give you 80% value of pushing your innovation into patents. So I have compiled this session with very simple tips and tricks. So it is not technical. The session is not very technical. It's very, very practical, and things that you can, just start to do now. Things you can start to do now to, increase the chances of having a patent. So I will share my screen, and if possible, I will ask you a question to start with. So let me know if you see my slides, because in the past I have had problems that they could not see my slides.
Visible, it is visible.
Okay, all right. So I want to start with a question. So the topic for today is research to patent, a very, very practical overview, how you can mature your research into patents. So first, I would like to ask you a question, if possible, write on the chat. And if the chat is enabled, I can read the chat. I want you to tell me what is the difference between an idea and an invention. So if the chat is not working, maybe one or two people can just use their mic and just let me know. So what is the difference between an idea and an invention? So a very, very simple question, but that is the entire trick. The trick lies entirely in the answer to this question that we will discuss during this lecture. So let me see if the chat is visible. Can I see the chat? No, actually the chat is disabled, ma'am. It is only for team members. So it's okay till if it's not fixed, then someone can just use the mic, and someone is raising the hand. If they want, they can use the mic and answer. Yeah. Syed Sadiq Ali, if you
Please unmute your spell and speak, sir.
Sadiq,
Hello, sir.
Unmute yourself. Unmute yourself and you can talk, sir.
Yes, sir.
Yes.
I am Major Varghese.
Am I audible, sir?
Yeah.
Yeah.
Okay.
Sir,
Good evening, one and all. Okay, an idea is the starting point of the new thought or invention or creativity based upon the context, and whereas the invention is a valid idea is considered as invention. It's a further step.
Yes. Okay. Perfect. Actually, most of you, you might all have answers. Okay, Shivani, if we can have one more person to.
Yes, sir. Sir, idea could be defined as a creativity of mind, and invention could be defined as a something which are having a commercial purpose and having an inventive step, and somehow it is going to help to the large society or to the large world. That could be defined as an invention.
Mm-hmm. Great. Thank you. So I'm sure that all of you can answer this question, and all of you will have slight permutations and combinations of the answers that we just got. So that's perfect. I'll just give you all my own definition. Can you still see my screen? Can you please confirm, ma'am, once again?
Yes, sir.
Yes, sir.
All right. Okay. So an idea, it becomes an invention when it can be described in sufficient detail. So I have highlighted described in sufficient detail. Actually, that sufficient can be actually quite extensive. So you might have to define your idea in quite extensive details. Okay, so this is the whole crux of the matter that we will discuss today. That how you can take an idea that is in your head to to describe it in so much detail that it starts to become an invention and starts to become useful. So think about just like a stone. Okay, there's a stone, and there's a very good sculptor who carves the stone. So he carves the stone, and then slowly the stone becomes a statue. That so this is what I want you to think. An idea is just a stone, and the statue, that is the final output. That is when you start to describe your idea in more and more precise details. That's when you get the final output. That's a creation that you finally have. So a stone is not a creation in itself, but it's an idea. You can do whatever you want with it, and then finally when you carve it, and you finally get a statue, which is a creation. So can an idea be patented? Answer is no. can an idea be copyrighted? Even now, the answer is no. So basically, in terms of protection, there is no value of ideas. So if you have something in your mind, then it's as good as it's not useful at all. So in patents, if you want to mature your research into patents, so if you just understand this one line of this entire lecture, it will be useful for you. So that's just one line. So if you're thinking about patents, writing is the most important part, which will start when you start to describe your idea. So how do you describe an idea? You describe it by writing. So writing is so important that even today, say in your bachelor thesis or master's thesis or PhD thesis. Hello, can you please mute yourself? Hello, yes, okay, great. So writing is something that you always have to do in your academic ecosystem. You always have to write your bachelor thesis, master's thesis, PhD thesis, and research papers and so on. So why do you think you have to write all that? Because unless you write, nobody's thinking that you've done anything or you've researched anything or done any project. So the final output is still a written content that you have. Even a journal is going to accept a paper that is 5,000-10,000 words, and then only they will say that, okay, you have done research which is unique and it takes the field of science forward. So writing is one of the most important ways how you can start to extract features from your idea. So one by one, you write, you describe, how your components work, how the components work together. So this lecture is all about that. I'm going to tell you how you can write, what references you can take to write, so that your invention starts to be complete and ready for patenting. So one of the easiest way to write is to use the reference of an invention disclosure form. So actually, this is the secret. If any institute, so if I have to advise an institute how to boost the number of patents, then I would say that you have to implement and execute an invention disclosure form. So that form will be given to inventors. They will I will show you how you can fill that form, and if you implement that, the chances of getting more and more inventions will increase. And I will show you why invention disclosure form. Many institutes are implementing it, but they are implementing it as a formality. They just quickly, the inventors are filling it like abstract and summary of invention and so on. But I'll show you why invention disclosure form is not a formality, and it can take even many months to fulfill the invention disclosure form properly. So quick statistics. I don't want to use too much time here. This is the patenting of top 5 patent offices in the world. You can see China is about 1.5, 1.6 million every year, and all the other patent offices are, US is 600,000 and so on. So globally, 3.5 million patents are being filed per year. And if I want to show you the Indian stats, so Indian stats are not very easily available, but from the patent office and from our own platform, IPgram, we have compiled these statistics. So approximately in India, 50,000 patents are filed per year. And that is, 30 times less than 1.5 million. So you can imagine how small the total volume of patenting is in India. And who are the top filers? So this is one of the charts to see who are the top filers. So you can see here Qualcomm, Samsung, Huawei, Ericsson, Philips, Robert Bosch, and so on, General Electric. So all these companies you see, they are the top filers in India, and they are all foreign companies. So this is what I wanted to show you. The first company, the first institute that is an Indian entity in this top list of patent filers is actually on number 14, and that is CSIR. You might know CSIR. It has so many research. It's a government research institute. So many research institutes across India, and together, they are number 14 on the list of top Indian filers. So you can imagine how far behind. Out of these 50,000, only about 17,000 are Indian residents who are filing, or Indian entities. So the rest 33,000 are actually foreign companies who are filing in India. So the point being that these numbers are so low that we basically need 1 or 2 generations of inventors, of researchers like you, master student, PhD students, to convert their thesis, convert their research into patents. So after 2 generations, we will be able to, catch up with the volume of patenting that really helps India to solve, the challenges faced by, so many challenges like COVID-19, climate change, and security, defense. So like many different things, social things. So for solving all these challenges, innovation will be at the center stage. So that's why what I wanted to basically emphasize that this is where we start from. All right. So I mentioned about the invention disclosure form. So I'm going to do a breakdown about what an invention disclosure form and why it is the most critical aspect of an early stage innovation. So first thing you have to define in an invention disclosure form, we will actually look at a real invention disclosure form from a WIPO website. So just I'm giving you a quick breakdown so that it stays within, so what problem does the invention solve? So you have to write in detail. What are the commercial applications of the technology? Then you have to describe the invention in detail, how it works. So basically everything that will finally go into your patent document. And how is the technology better, different from existing solutions that solve the same problem? So some brief prior art search or patent search might be needed when you do, so that you can. So prior art search is very important because you want to. How else will you show the differentiation between what you have added to the current research? So brief prior art search is needed, and I'm going to take you like in the early stages. You don't need to do highly precise patent search, but everyone can do a simple patent search, and I will show you in like 2 to 3 minutes. I'll show you. So okay, so this is about the invention disclosure form, and one thing to note is that invention disclosure form is not a formality. So you have to think like this: innovation happens when you fill the invention disclosure forms. So while you are filling the invention disclosure form, that is when your idea is maturing. So you might have, whoever who has written a master's thesis or PhD thesis, you might have, found out one thing that happens when you start writing your thesis. New ideas start to come. Then that's when innovation is happening, and it is always true. Whenever you get down and start writing on your computer, that's when brain starts to think. And you make new connections, you find new things, and you compile, and finally, So a lot of people say that, they did research for 4 years in a PhD, but the actual research happened, or the actual, invention happened when they started to write their thesis. So this is what invention disclosure form is. If you, in terms of patents, if I have to take the same thing into patents, this is what invention disclosure form helps in. So, I will show you one invention disclosure form very quickly to give you an idea how extensive it is. It is why it is not a formality. So I have this open. So I basically just typed WIPO invention disclosure form in Google. Okay, and I found this document at the top. So I am just showing you that. I won't show you the whole document. It is like very, very big, 33 pages, but so that you get an idea, what is out there. So these are some questions. So first, let's say you start with the title. Then you have to mention all the inventors. So at this stage, just knowing who the other inventors are is very important, because patents are a commercial right, and it is very normal that it leads to disputes in the future. So it's not uncommon to have patents end up in court. That is why in the very beginning, it should be clear who the inventors are properly, with their name, with their all the kinds of details. And so if you have 3 inventors or 4 inventors, there should not be any confusion. So even at this stage, this is a problem that the invention disclosure form solves. Then you describe the invention. So here there are some guidelines also. It says, do not describe the invention, but focus on the problem found in existing technology. So that's the first thing you should start with. So, okay, existing technology has some deficiencies, and this is what your invention is solving. So it's like the very, very first thing that is needed. Stage of development, summary of invention. Here again, when you describe the invention in detail, it says consider the commercial applications of technology. So whatever you have built, service, process, technology, product, how it can be applied to a product, process, and service. So whatever technology you have to see, where it will be applied. So again, these are all also important, for you to finally get a patent. And then comes the date of invention. The second most common disputes happen in patents because of who has, done the patent, who has researched earlier, who has invented that certain thing, earlier. So it is a good time in the invention disclosure form is a good time to note all these things in paper, and here you don't just write the date. You even have to provide proof, because the examiner, the patent office can ask you, show us some laboratory records, show us, something. So here you should, whatever you have, the origin of the idea, you mention the names, the proof, any kind of charts, any kind of, lab data, whatever you have, it's a good thing to note it down, and it can avoid so many problems in the future. You can see it goes like that. The competitive advantage, application. So I won't go into the entire invention disclosure form. So you can go it on your own. So I just type WIPO, WIPO, you can see this, and invention disclosure form. That's all I type. Yeah, sources of funding, for example, it's an important aspect, because the person who's funding you, the institute who is funding you, they have an agreement with you. So you should mention what kind of agreement they have. Do they have a share in the patent, or do they not have? All these kinds of things are a good thing to clarify right before you file a patent, while you are in the early stages of filling the invention disclosure form. Right here it says, do you have any obligations? If yes, what are the obligations? So that it's on record right at the very beginning. Whoever has helped you, for example, and so on. So if you want, contact me. I think gave you my contact in the very beginning. I can give you a sample of some invention disclosure form that we use. So rkapoor@ipgram.in. My email and my phone and WhatsApp is this phone number. All right, so let's move on. So we've did the invention disclosure form, and how to write, some guidelines. So we'll quickly walk through some guidelines, like how you should write, how you should think. So first, you can broadly define the problem. Put some general thoughts in the beginning, like what broadly the problem is being solved. How are the various components structured? Okay, and here it is a good idea to draw. So again, I mentioned the importance of writing. Actually, the importance of drawing is together with writing. So you should not just write. You should draw as much as possible, because patent examiners like it, and not just like it. It's important that you clearly show how your invention works. We will actually see one patent, and you can see how a good patent is written, and so many drawings are there, so that because drawing will be very important, because you will have to explain your invention to everyone in the future, to the patent agent, to the examiner, maybe in the future to some licensing people, to some judge if it ends up in court. So always, drawing is important. I will talk a bit about drawing also. So describe each element and how do they interact and connect to each other. So each and every component of your invention, if has to be defined, and how components interact with each other. So this is finally in your patent, every component has to be numbered and defined, what it does, and if needed, describe the external environment in which your invention operates. For example, your invention requires an external 12-volt battery supply. So you should write it that, okay, you need this, you need power from somewhere, or invention requires to, a certain humidity level or a certain indoor conditions, lack of sunlight. So all these external environment you can take to define, in one aspect. By the way, the presentation is not available, so I'm not sharing the presentation, but feel free to take screenshots, okay, that where you think that, it's a good idea. So just, just take screenshots of this and describe the overall function the system provides, and write the differentiating points with prior art. It is very important that you write how it is different, because the more you write how it is different, the more chances are that you will be found to be novel and, yeah. So the thing is, at this stage, when you are in the early stage of an invention, no one knows more about the invention than the inventor themselves. Okay, even your PhD supervisor doesn't know as much as a PhD student, because PhD student is doing only one thing, and PhD supervisor is doing many things. So so because you are the one person who knows the most, you are the person who has to start to write, because even a patent agent will not help you in writing the invention. They will help you in finalizing the drafting. They will help you in finalizing in writing the claims. They will help you in filing, and they will guide you, how to enhance the patentability of your invention. But they will not write it for you, at least the technical part, because the patent agent files 10 to 20 applications a month. Okay, so it's unlikely that they have so much knowledge about an invention. So, okay, I told you about the importance of drawings. So here I mentioned a few. So drawings aid in understanding the invention very clearly. And that is a basic tenet of the patent law, that your invention has to be understandable. Okay, if it's not very understandable, it is grounds for refusal. So you can be, patent can be rejected. Or even a third party can oppose a patent, that, hey, a skilled person cannot understand it. So even like in the future, you might have to communicate your invention to the patent agent, patent examiner, and possibly even a judge. So all the time, you have to communicate your invention, and that's where, drawings really help. And it goes without saying, but I have mentioned it, that good drawings create stronger patents. That's it. So always remember, use some basic tools, PowerPoint, or, some online tools, just to draw flow charts. Okay, this happens, this happens, this happens, and this is the process. This is how things are connected. So first drawings are usually drawn by the inventors themselves. And if, the situation demands that you have to take professional help, go for it. But mostly at the way, academic institutes I've seen in India, the inventors are primarily responsible for drawing. Okay, and then of course, make sure that your invention is patentable. So you can read a bit. So I have noted some of the most important things here, that what cannot be patented. And you can see, if you type Section 3 of the India Patent Act, if you just type in Google Section 3, so Section 3 of the India Patent Act has all the non-patentable inventions. So you can see frivolous or contrary to established natural laws. So frivolous, like inventions, no. Anything contrary to public order, a method of agriculture or horticulture, it's not patentable. Any literary, dramatic, musical, artistic work, it's copyright. It's not in the field of patents. Plants or animals in whole or in part thereof, they cannot be patented. And finally, mathematical and business methods, any mathematical model or algorithm or business method or just computer program per se. By per se, it means just the computer program. They are not patentable. So just, refer to the Section 3 so that, you know that you are in the patentable criteria, and if not, to learn, what can make it in the patentable criteria. So these are the patentable criteria. I'm sure you have, seen other lectures on IPR. So I will not go in depth of all these patentability criteria, but it goes without saying that it has to be new or novel. Novelty is the most important thing. Okay, you cannot patent something that's already done. It doesn't make any sense even. So inventiveness means that it should be a significant improvement. Okay, it should not be frivolous improvements. Like, say you add a fifth leg to a chair. It's like, it can be frivolous. It can be, saying that it's not inventive. And industrial applicability, it should have a commercial application. It should be useful in general. Okay, so a typical patent timeline. The reason I'm showing you this, actually, I'll show you the Indian version. So this is a general, I've said, that 18 months it takes from the time you file it to the time it is published. 12 months window you have to go to foreign countries. If you think that your invention is global and you might need foreign applications, you have 12 months to think about it. And then everywhere across the world, even like 4 to 5 years, it's needed to get a grant decision. Nowadays, there are some channels where I have heard some grants have happened in 1 year, but they are rare cases. So if you take an average, it takes 3 to 5 years. So here is an Indian version of this. So first you will do a filing. And during filing, you can actually do request for early publication. So within 30 days, your patent will be published. There's a fee for this, but if you don't pay the fee, early publication fee, it will be published after 18 months. Then you have to also request for an examination, because examination is not automatic in India. So you have to pay a fee and tell the patent office that, hey, please request, accept this request to examine my patent. And then examination happens, which takes 2-3 years. And during examination, third parties can even oppose the patent. Let's say that, okay, this is not patentable because of XYZ reasons. And then you might have to even answer some questions regarding that. And then usually there will be a first examination report. When the examination is complete, the examiner will get some objections, and the inventor along with the patent agent will have to answer those objections. And then finally it is refused or granted. So, and then the procedure follows after that. So okay, the contents of the patent application, again, I would like you to take a screenshot at the end of this slide, so that you know that these are the things definitely you have to write. And for the most part, so title of the invention, usually in 15 words. The field of invention, it's usually a short paragraph that describes the scope of the invention, so that the examiner can easily understand, okay, in general, what technology it is. So I'll show you one example also of this. Background of the invention, the state of the art, what is currently present, all the prior art, what are the deficiencies of the prior art, and so on. Object of the invention, so what exact solution that your invention has what solution that your invention has researched, what you have researched. Statement of the invention, so like what constitutes as novelty and inventiveness, so related to the previous literature. Summary of the invention, which is a broad summary, and a brief description of all the drawings. So all the drawings have to be described in the final drafted patent. Each and every numbers in the drawing should have a reference, and so a detailed description, a complete picture of inventions, how the components are together, how the methodology is, how the the steps are. Say first you do X, then you do Y, then you do Z. So all the things as much detail as possible. Claims are usually drafted by experts, because they are techno-legal text, and even examiners don't prefer that inventors themselves write claims, because they know inventors will make mistakes, and it just makes the job of the examiner harder. So it is always a good idea to finally, you write most of it, but you get the help of a patent agent who will help you to, make these better, and also to help to draft the claims in the best possible way. So please take a screenshot of this in case, it helps to like what to write, then like these are the things you will definitely have to write. So, all right, moving on. There is an option for provisional patent, but I think I don't talk about details today. So you can contact me if you want. So I want to do some bit more practical things. That's why I want to skip this provisional patent things. But yeah, a little bit of search is important while you are filling the invention disclosure form. Even at that stage, some search is important, because simply to avoid reinventing the wheel. Even though it sounds very simple, avoid reinventing the wheel, most people still do it. Actually, there is even some research that said that 30% of R&D costs in the whole world is actually wasted, because people are just doing, they're not seeing what is already out there, and they're just doing in their mind, they think it's unique, and they just start to do it. And it's the inventors always, they have a high opinion about themselves. They think that what they are doing, no one else is doing. But when they start to do an actual patent search, then they realize, okay, others have already done it. So it's very normal. Okay, so don't fall for this. Don't fall for your own pride. Always do search, because it will also help you if you inadvertently infringe somebody. It will also help you that. And the second most important thing about searching is that it is not just about finding what is out there. You can learn from other patents. So searching is so important in the beginning, because what I want you to understand is that, innovation is not one-shot action. It is not happening all at once. It is happening over the years. It takes many years to, an invention to mature. We saw even 5 years it is taking for granted, but things are happening in those 5 years also. So you can learn from existing patents and enrich your own inventions. Maybe you can combine two different concepts, and the concept that you come up with is significantly better than the combined concepts. And also the prior art search or the existing patents, they help to crystallize the novelty and inventive step part. So how will you show, for example, if there is no prior art, how will you show that you are unique? Okay, you need a reference to show that this is what you have added and this is what unique things that you have done. So actually it's a good that you have prior art. So it's not a bad news that you have prior art. It is good news that you can start to differentiate yourself. So this is like the importance of searching. So we will do like a very quick 2-3 minute exercise today itself to before the time runs out to do this. But first, I would like you to all to go to worldwide.espacenet.com. Okay, worldwide.espacenet.com, and I want you to search this particular patent number. It's one of the most blockbuster patents of Apple. Okay, right from the 2006, it is one of the most famous patents of Apple. So US 2006 026521. I will also do it with you, but I want you yourself open a new browser tab, search worldwide.espacenet.com and search this number. So if you can access the chat, write on the chat what the title of the patent is, and if not, you can also unmute yourself, one or two people, and just say what the title is. So I will see the chat if there is. No, I can still not access the chat. All right, so anyone who wants, they can unmute themselves and tell the title of the patent. And after that, I will also search it actually. I will also search it.
Sir, can I skip?
Yeah, please.
Sir, okay, I would like to search about artificial intelligence in connection to good governance.
Yeah, but right now we are not talking about it. Right now, I gave you this exercise. We are going to do that.
Okay.
So if you see, I told you to search worldwide.espacenet.com. Go to this website and search this particular patent.
Okay. Thank you so much.
So anyone? So I think I'll wait for like 30 seconds if someone wants to speak, and then I will show you, how.
So 1 second, please share the screen, sir.
Yeah. Can you see now?
No, sir.
Okay.
Yes, sir. Now, okay.
Okay, yeah.
So the title of the patent is Gestures for Touch Sensitive Input Devices.
Can you please repeat?
Gestures for Touch Sensitive Input Devices.
Yes.
Yes,
Perfect.
sir. The same.
Perfect.
2006 to Apple computer.
Yes, you're right. So eSpaceNet is a great tool for patent search, and I will show you how to do a quick search today so that everyone can do that. So it's not technical, it's everyone can do that. I'll just show you. But first, I wanted to show you this application. The reason I selected this application, it's one of the most, fantastic patent in the sense that how they have written. It's like, of course, Apple has huge budgets. They have great people to draft the patents, draw the drawings. You will see how clearly they have mentioned everything and how well they have explained everything. So this is what I wanted to show you. So this is the eSpaceNet user interface. You can see, at first you can see the bibliographic details, which is the name of the applicant, name of the inventors, technology classes. So you can even click on these to see what technologies in general it belongs to. You can see all the global patents they have filed for the same invention, and then the title and abstract over here. So you can see very simple abstract. And if you want to see details, you can go to description. And now you can see how well it is drafted. So this is what I meant earlier when I said background of the invention. So they have written, the present patent, gestures associated with touch sensitive devices, just, simply what the patent is about. And then it's actually a long patent. So they have mentioned, there's huge number of figures, up to 30 figures, and they have described each and every figures. And it is like incredible how clearly they have mentioned each and every, you'll see the figures here. Also, the figures say very well how they capture the gesture, how user is touching the screen, how the electrical signals are being processed when the user is touching the screen. So you will see everything. Yeah, you can see here. This is how the touch is, that when a person touches the smartphone, and how they take the coordinates of the input, and how they capture, how they process the coordinates. All these kind of flowcharts are there. How the user is interacting with the screen. So everything that is possible is there. So which, even like how to prevent spurious clicks, like, to just assume where the person wants to click, and so on. Basically, even like a use case has been showed that how a person can zoom in, zoom out, use the pinch gesture to be able to, like this, like using the pinch gesture to zoom in and zoom out. So this is like from 2006, when these things were not very, common. Nowadays, it's very common. We are using all of this, but you can see how well they have, defined, shown the pictures and seen that. So you can actually look at the original document, download it, keep it with yourself as a reference, just to see how a good patent is. Learn from, their patent, their drafting, their claims. See how they have written the claims. These are the claims. You can see. See how they have drafted the whole invention. Okay, so yeah, so this is what I wanted to show you. All right, so moving on, I want to show you like quick and dirty search. Okay, so who asked me earlier? Someone asked me. Sajid, maybe someone, yeah, asked me about artificial intelligence. So I'm going to show you how to do normal patent search. Okay, in like less than 5 minutes, I'll show you. Okay, so of course it's a huge field of research, but in the early, it's a huge field, patent search. You can go very technical, but for the early stage inventions, at the stage when you want to mature your idea into a patent, this is all that you need, and everyone should know this. So suppose. So I'll show you no operators needed. Okay, quick and dirty search. If you want, I can also show you, if the time is there, to a bit more precise searches. But let's, you are already there on espacenet.com. So I will show you how you can perform a quick and dirty patent search. Yeah, someone is saying something. No, okay. All right, so I'll just show you a quick and dirty patent search for wind turbines. So suppose I am a researcher in the field of wind turbines. I am opening this espacenet website, and in the search bar, I'm just typing wind turbine. That's it. Nothing more than wind turbine. Now you can see here that the number of results are a lot, right? Nobody can read all these patents to see which is relevant. So the first thing that espacenet does is that it sorts by relevance. So these two words, depending on the frequencies and by the normalized scores of these words within the text of the patent, it gives the most important patents at the top. So usually you don't have to go through more than 20 to 50 patents from the top to know that, okay, if your search is relevant or not. So you can, and also you can quickly browse. You can quickly say if you are in bibliographic data, you can quickly see the abstract and title and the images to see useful or not useful. So if it's useful, you can see the description, claims, more details. If not, just move on to the next patent and just carry on with your search. But wind turbine is a broad technology field, right? It's unlikely that you are doing research in such a broad technology field. So what you must be doing must be very precise. So earlier when I said you have to describe your invention in sufficient detail, that is what we are doing right now. So you are going to keep adding objects and functions to your keywords. So wind turbine, suppose wind turbine is very broad. You are working related to wind turbine generators. So I just use the word generator, wind turbine generator. And now you can see from 230,000, it became 120,000. So almost like half the number of results. So your search is becoming narrow as you type, more and more objects and functions to your search. So you can see here, and the relevance score makes sure that the most important patents are at the top. So now you can see all these patents are, the most important related to wind turbine generators. Now, suppose, when wind turbines actually function, the generator actually produces a lot of heat. Okay, so there has to be an active cooling mechanism within those generators to basically cool them down while they are operating. So suppose you are an inventor that is solving that particular problem. So let's just say cooling. You are a person who wants to find patents that do wind turbine generator cooling. So now you can see from 120,000, the results became 24,000. So you see where I'm going. I'm continuously adding more and more features and more objects to my invention, and I'm narrowing down the results. And then the sorting score is taking care of the rest. Now you can see there will be cooling related keywords. There will be generator related keywords, and the most important patents are going to be automatically on the top. So you can see that there's a certain infrastructure for cooling, and you don't need to stop here. Suppose the cooling needs to be done by water. Suppose there has to be a pump in the cooling system. So say you are designing a unit that, which has a pump, which is, maybe has some channels or paths where the water is going to flow, how it is going to flow, a pipe, all these things, you can now start to write very, very precise keywords. And so now you can see only 3,000 results, and only the top, say, 20-50 results are going to be, what you might be looking for. So this is what I mean, that, this is a quick and dirty patent search. You are adding features and objects and features to your invention. Your idea is becoming an invention. You see, you are adding details. You are continuously adding details. You are carving the stone, basically. The wind turbine was a stone, and now when you keep adding, these keywords, it's becoming a statue. So yeah. This is a quick and dirty patent search. I hope you can use it even for artificial intelligence. Use those words that you mentioned to me and try to see what results are coming at the top. Believe me, the relevance score works. Okay, I know how they are normalizing it. So we ourselves built our own patent analytics application, IPgram, and it had 100 million patents, and we were searching ourselves using these relevance scores. So okay, moving on. To the last stage of this lecture. Yes, I mean, when you are doing professional patent searches, you will have to encounter patent jargon. For example, spring can be noted as energy storage means, ball bearings, plurality of balls, drones almost always are written as unmanned aerial vehicle or UAV, remotely controlled aircraft. So you have to add all these synonyms to make your search a bit more precise. So yeah. As you mature your invention, probably you will do this. But really, in the early stage, when you want to do an idea validation, it's enough what I just told you. Just run some permutation and combinations of those. So as an exercise, I can give you very, very quick idea about OR and operators. So all you have to do is go to espacenet.com, which is already open, I guess, on your screen. Type these things. Suppose you are a fuel cell, you want to search. I want you to tell me the number of hits you get for fuel or cell, fuel and cell, and fuel cell. So fuel and cell is that both fuel and cell words have to exist, right? And fuel or cell is either fuel or cell can exist. This will give the widest results. And fuel cell in quotation marks will be like these two words have to be together. This means that both words have to be there, but they can be present anywhere in the text. So if anyone can, tell me the number of hits you get on eSpaceNet, will be great. Then I know that the audience.
Fuel or cell?
Fuel or cell, yeah. Number of hits. So I want
7,46,000. No. 74 lakhs 62,061.
Yes, 74 lakh. That's a lot, right? this search is useless because it's, even the word cell can be there. It has nothing to do with fuel cell. So you have to search either of these two. So how much for fuel and cell?
4,66,336.
Exactly. So imagine from 74 lakhs, it came to 4 lakhs. And how about this fuel cell?
Yes.
In like.
Same count.
No, it cannot be same. It has to be less. Fuel cell with quotation
2
marks.
lakhs 2,86,728.
Yes, 2 lakhs, something like that. Yeah,
Yes.
yeah, perfect. Thank you. This is great. So I'll tell you folks, all professional patent searches are, advanced version of these simple operators. So if you can understand these operators, you can basically take, keep adding and or operators and, mature your inventions. If you want, I actually did a very, very comprehensive webinar, even 2-hour webinars I have done on both eSpaceNet and patents and Google patents. So I have done a very thorough breakdown of the patent search in both. If you want the recording of those videos, just write to me on my email and I will send you. So yeah, here if you see, there's also a wildcard I can show you. So instead of cooling, if I just use the star, cool star, so it takes cool, cooled, cooling, coolant, all these, variations. And now you can see 3236 will probably become more. So some of the variations we were not taking a bit more, a few more, because we were not taking some variations because of writing cooling. So yeah, these are some wildcards that you can use. Take a screenshot of this page and do this in your own time. It's a simple exercise using the same concepts that I have mentioned. Creating high efficiency fuel cells requires proper cooling. Okay, same as in wind turbines, you need fuel cells when they are operating, they need proper cooling. So suppose you have your objective is to search fuel cells you have to search in automobiles or vehicles, and there should be a cooling arrangement within the fuel cells. So these are the three concepts together that should be there incorporated in your search. So when you search, it should be, I have given you the hint over here. Fuel cell is the one concept, and then you put an and, a vehicle is the second concept, put an and, cooling is the third concept. So this should give you a broad search of what you're looking for. If you want to use the wildcard, you can use this wildcard that I suggested, coolant. Coolant, cooling, cooled, all these will be taken care of. And synonyms, earlier I was saying that if you can take synonyms. So cooling is sometimes written as heat transfer. So you have to write, say, within brackets, all the and will say, but these concepts, say within brackets, can be cool star or heat transfer. So just refer to this and you will, get the hang of it. Add more filters if necessary, if you want, more filters here. So, all right, folks, so I'm at the end of the, but I do have some last words, some like 5 minutes I'm going to take. Filing fee is very low for individuals. So the government fee, I think, will not be like very big. So 1,600 rupees. I think even for institutes, universities, it's now 1,600 rupees. Earlier it was 8,000. So 1,600 rupees is the patent filing fee in India. If you want a quick publication, within 1 month, they will publish your application. You have to pay 2,500 rupees, but this is optional. If you don't pay it, your patent will be published after 18 months. Patent is not automatically examined, like I mentioned earlier. So you within 4 years of filing, you have to pay a 4,000 rupees fee. So usually it is paid along with filing only, because as such you want the patent to be examined, right? Otherwise, why are you filing? So 4,000 rupees for individuals needs to be paid. So 4,000 rupees plus 1,600 is mandatory, I think, earlier. So 5,600 is government fee. If you want to add this 2,500, it can be 8,100 rupees. And then after the examination is done, you will probably need some help to answer the objections of the examiners, or respond to the FER, respond to the first examination report. And then on top of this will be your patent attorney fee or the patent agent fee, who's going to help you, who's going to draft the claims and in general take care of the entire process. Some general tips. adopt and implement a comprehensive invention disclosure. So it's very, very important. Okay, so don't take it as a formality, don't take it lightly. An invention disclosure form is when innovation is happening. Entrepreneurial mindset is needed to bring innovation to market. By entrepreneurial mindset, I mean that, look, you involve a patent agent. How do you involve a patent agent? There are so many patent agents in India. You just search on Google some law firms, call them, tell them their problems. At least 5 patent agents you should talk to, okay? So that you understand what the costs are, what are, how they are going to help, how they are going to give you, personalized attention. So that's what I mean by entrepreneurial mindset, that, you pick up the phone and you call some people, you kind of get an idea. Otherwise, you will never get an idea if you don't call. If you just sit, a patent agent is not going to automatically come to your doorstep and help you. So always, be forthcoming, go out there and, so get, with patent agent, you can get help to extract your invention also from your idea. Okay, so you have a broad idea. They can also help in, for example, what can be shown as patentable, in an invention. Of course, if needed, they can conduct professional prior art searches, a bit more precise. Writing claims should almost always be a patent agent's job, because they are experts and they are able to do it. An inventor usually will not be able to do it. And yeah, do not delay. I mean, when you start the process of filing patent, it's a great learning curve. And believe me, if you want to be a prolific inventor, that you want tens and tens of patents in your career, you need to start now, so that in 5-10 years, you will, as an inventor, you can have a portfolio of 10 patents or something like that. So, and with every patent, you learn more and more. So the next patent will become easier. So the trick is to start with 1 patent, and your 2nd, 3rd, 4th patents will be much easier with the experience you have for the first patent. And conclusion is that hard work is needed. So be prepared for the hard work that is needed in the entire process. So yeah, that's the end of my lecture. These are my contact details. You can contact me on email, write to me if you want. You can write to me on LinkedIn. Send a note if you're sending a connection request. If you don't send a note, I'm not accepting it. And call me or WhatsApp me on this number. You can go to our website, turnip.co.in. You can sign up for free on the so that we inform you about our events. There's also links to our, there's 2 courses at least we have for free, one on patent analytics and one on product management. And I also have a 2-week patent course, which is 199 rupees. It is also there in the website. So turnip.co.in. So, all right, folks, I thank you a lot. I can take a couple of questions, like 5 more minutes. I can stick around, and then we can. Yeah, I hope it was useful for you.
Yes, sir. Thank you very much, sir.
Any questions from anyone?
Any?
Yeah, please. I'm happy to take questions. Yeah.
Sir, this is Dr. Anjaya, Department of CSE. So, sir, I have 2 doubts, sir. So, 2 questions, sir, I have. So, first question is there any difference between normal patent and utility patent? And my second question is how to get grants easily, sir? Is there any method to get grants easily? Grants getting is very tough task,
Yeah.
sir. How to get? Yeah, sir.
Yeah,
Please.
I don't know about any methods to get easily. Yeah, you follow the process well as possible. Do all the hard work, So result is not up to you. You are supposed to do the work, not think about the result. Like, from our philosophy in India, it's like, do the work, not think about the result. So yeah, any tips and tricks like that, I don't have. Okay. Regarding utility patent, yeah, it's different. It's a petty patent and it has a smaller duration. So I don't know about precise actually law aspect of that in India. But utility patent is usually 10 years and it does not have a very good examination process. So it's yeah, I think that it's likely to be just filed and issued. So yeah, I actually don't know, but if you contact me with something precise regarding this, we will have a patent agent call you, so you can ask them.
Yeah. Good evening. I'm Syed Sadiq Ali from Department of SN.
Yeah.
Sir, just I would like to know that what is the total cost involved in getting an Indian patent grant from the starting from application to the grant? What is the total cost involved if 10 people are involved in the particular patent?
There's a schedule of fees, Indian Patent Office. So look, I am showing you the government fees.
Yes, sir.
Okay, fees and forms and fees. So if you just search on Google forms and fees, Indian Patent Office, you will get this link, forms and fees. Okay. There's all kinds of fees that are there. So I will show you the main things. I think this is the one, yeah, fees. So usually for small like startups and individuals, this is the column that you have to refer to. So patent, if you involve a professional person, the professional fees can be anything from 20,000 to 2 lakhs, depending on if it's a big law firm. If it's a big company, they want very, very precise, drafting. So they will go for really the high end servicing. So there are also patent agents who do it for much less. So I would say for institutes, I have seen 20,000 to even like 80,000 as professional fees. And you can see the filing fee is 1,600 rupees. Then 30 pages are included. If you add more than 30 pages, 160 rupees per page. And then even claims, there are 10 claims included. You have to, if you add more claims, I think 320 rupees per claim. Then request for examination, I think 2,500 rupees from, from 12. This one, request for publication is 2,500. Then opposition is there, 4,000. I told you examination fee is there. When you respond to FER, there is no fee from the government, but say you take help from the patent agent, so you might have to pay them. If there is opposition, then there might be, some more fees. And also you can see here, there's a maintenance fee. So if your patent is issued from the second year, you have to pay 800 rupees. And as your patent, reaches the end of term, which is 20 years, you have to pay up to even 8,000 rupees. So it keeps getting more expensive to maintain a patent. But the thing is, this 8,000 is nothing. If you have a commercialized patent, it is fetching you licensing revenue. It can be in lakhs or crores, depending on the whose patent is and what the invention is. And so they have to, pay more and more. So yeah.
Sir,
and if you don't pay, it is lapsed. Okay.
Yes,
Tell me.
Sir, my question is, if 10 people are involved in a patent in different aspects, then is there any special fee involved in adding more number of people?
I don't think so. But we can see. I don't think so. I don't think the inventor is a factor. So yeah, you can. You can write to me and I will confirm it with the patent agents that we have. Okay.
Okay.
So
okay.
Thank you, rkapoor@ipgram.in.
Okay.
All right. If you have one last question, I'm still up for. And if not, then.
Hello, sir. Sir, this is Bhaskar from
the
department, sir.
Yeah.
Sir, actually, once the patent has been filed and it has been granted, and in future it are going for any upgradation, okay, can we need to refile it, or already we have filed it, sir? We can go for upgradation of it.
There is something called patent of addition. Okay, I want you to, you can search it online. Patent of addition, India Patent Office. Okay, it will give you all the details what you're looking for. So as I understand, it is the same invention, but you have added some features to it. And in such a case, patent of addition you should file. Okay.
Okay, sir. Thank you, sir.
All right. All right, folks. I wish you good luck. I wish some part of the lecture was useful, and I hope you will make use of these learnings in your career. File a few patents and even like tens of patents And yeah, good luck. Happy to be in touch. Thank you to the organizers. Thank you for inviting me. And yeah, with your permission, I would say goodbye.
Yes, sir. Thank you, sir. Thank you very much. This is Dr. Srilata, Principal of St. Peter's Engineering College.
Thank you, ma'am, for having
the
me.
management and faculty members, I thank you very much for the thing. And even for the faculty who are at the young age and then are in thought of having patents and all, you have given a clear-cut idea for them. And the suggestions that you made are awesome. And even some certain doubts of mine also got cleared. I thank you very much for your acceptance. And we'll have another session in detail with 2-3 hours time spent, sir. This has given an input for the younger generation faculty members also onto the patents filing and other things. Thank you very much, sir. Thanks a lot.
Thank you. Thank you, ma'am. Thank you, everybody. Have a very, very good evening. Bye-bye.
Thank you, sir.